Lady, my lords. Before the luncheon adjournment, I was taking your lordships through the Strasbourg jurisprudence, and the Strasbourg jurisprudence is relevant to two issues. The first issue, which is the issue of whether the privilege applies at all to pre-existing documents. It's my submission that clearly Strasbourg has concluded that it does. And for that reason, the Court of Appeal and the Commissioner in these two cases erred in law in deciding that they did not. It also follows that the Court of Appeal judgments in the Attorney General's reference case, the Court of Appeal in the CPLC and P case, the Court of Appeal in the case of R.V. Kearns, the Court of Appeal in the case of Hundau, all erred in law because they proceeded on an assumption that Article 6 did not apply at all to pre-existing documents. The second issue is one that is more difficult, in my respectful submission, for the board to grapple with, because the courts below, having proceeded on the assumption that Article 6 did not apply at all, there's never been a balancing exercise, and there's never been findings of fact made relevant to that balancing exercise. And so all the points, for example, that my lady was putting to me before the luncheon adjournment are, of course, relevant to that balancing exercise. Now, I will address your lordships on the questions on issues that we respectfully submit are relevant to that balancing exercise. But what we respectfully urge the board to do is to allow the appeals to make declarations in relation to the tier notices of appeal, because that, of course, is now academic, or at least the notices have been withdrawn, and to quash the 1991 law notice, to set out what the relevant factors are that need to be taken into account. Because, of course, if you're with me on the first issue, then in all cases there will need to be consideration given to how the privilege against self-incrimination is to weigh in the balancing exercise. Now, before lunch, I had three more cases to take you to. But one of them is very helpfully crystallised in the context of the last case that I took you to, O'Halloran, and a submission that I was about to make before we broke for luncheon, which is this, that the so-called speeding cases are exceptional. That is my submission. And that they are the only context in which the Strasbourg court has found that the imposition of the cruel trilemma is not a breach of Article 6. And the key feature that distinguishes those cases is twofold. Firstly, the limited nature of the inquiry, and secondly, the particular regulatory context in which the individual can be taken to have impliedly accepted that these are part and parcel of being a road user. And I just wanted to take you to one case that's relevant to that distinction. It's Luckhoff and Spanner. It's volume 8, tab 83. It's page 4336 of the electronic bundle. Now, Luckhoff and Spanner is a driving case where the Strasbourg court applied the O'Halloran approach and found that there was no breach of Article 6 to require the individual to give his or her name or the name of the driver. But importantly, at paragraph 55 of the judgment, that is taken as a distinguishing feature in contradistinction with cases like Funke and JB. So if your lordships have page 4336, paragraph 55, the court said this: another similarity with the case of O'Halloran, this is in the context of the balancing exercise, Another similarity with the case of O'Halloran is the limited nature of the inquiry permitted by Section 103(2) of the Motor Vehicles Act. By virtue of both provisions, the authorities are only entitled to seek information as regards the name and address of the person who was the driver. In this context, the court reiterates in the case of Way, it's already found that the requirement to state a simple fact, namely who the driver of the car was not in itself incriminating. And in this, indeed, this distinguishes cases concerning the registered car keeper's obligation to disclose the identity of the driver from other cases, in which the authorities were entitled to seek comprehensive information or to subject the applications to extensive questioning. See Funke, JB, Healy, Shannon. Now, my lords, what this shows, this is the case that postdates O'Halloran, and it demonstrates that O'Halloran hasn't signalled a new approach by the Strasbourg Court in which it's going to reach different conclusions on cases that it had previously decided before the Grand Chamber decision by carrying out a more sensitive balancing exercise and allowing more weight to be given to the public interest context. What this case demonstrates is that the Strasbourg Court is reaffirming its previous decisions and demonstrating that the driving cases are exceptional. There were three more cases I wanted to very briefly take your lordships to. One goes to the first issue, that's to say whether the privilege is engaged at all in relation to documents, and two go to the issue of the balancing exercise, which we address under our issues 3 and 4 in our written case. Ibrahim against the United Kingdom, my lords, was the 25-7 bombers case. The facts of the case are not of concern. It's the statement of principle that one finds at paragraph 267, volume 3.
What bundle and tab?
It's volume 3, tab 25. Paragraph 267 is at page 2416. And my lords, this is a convenient way of tying together the submissions I made before lunch about what is the essential feature of that engages the privilege against self-incrimination. That's to say, it's the nature and degree of compulsion. So paragraph 267, it's important to recognise, this is another Grand Chamber decision. It's important to recognise that the privilege against self-incrimination does not protect against the making of an incriminating statement per se, but as noted above, against the obtaining of evidence by coercion or oppression. It's the existence of compulsion that gives rise to concerns as to whether the privilege has been respected. For this reason, the court must first consider the nature and degree of compulsion used to obtain the evidence. The court, through its case law, has identified at least 3 kinds of situations which give rise to concerns as to improper compulsion in breach of Article 6. The first is where a suspect is obliged to testify under threat of sanctions and either testifies in consequence or is sanctioned for refusing to do so. Now, those are, if you like, testimonial cases. The second is where physical or psychological pressure, often in the form of treatment which breaches Article 3, is applied to obtain real evidence or statements. See, for example, Jallow, Magee and Gefgen. Now, my lords, it would have been helpful if the Grand Chamber had said, for example, Funke and JB, but it's perfectly obvious that those are examples in which psychological pressure was used to obtain statements. And the third is where the authorities used subterfuge to elicit information that they were unable to obtain during questioning. See Allen, I took your lordships to that. And the other passage I wanted to take your lordships to is paragraph...
These are all examples of the authorities overbearing the will of the suspect by either forcible or underhand methods.
Undue is the term I would use, my lord.
Well, I can understand why you would prefer that term, but that's presumably the category in which you have to bring a case like the present,
yes,
where all that's happened is that a statutory power has been exercised to require the production of documents.
Well, my lord, it is a statutory power that compels a suspect in a criminal investigation to hand over evidence which is incriminating, which is or may be incriminating, under pain of criminal sanction. They're the very circumstances in which the privilege against self-incrimination has been found to apply at common law.
But that's not, why is that physical or psychological pressure?
It's the psychological pressure.
Power of statutory power.
Sorry.
Yes, I don't understand how you fit that into
Sorry,
physical and psychological pressure.
Psychological pressure is the pressure that comes from being placed in a situation where you either have to incriminate yourself, or
Well, no, you have to disclose some documents which you may or may not have. I mean, what's psychological about that?
We're assuming for present purposes that, well, not just assuming, the individual is a suspect in criminal proceedings. The evidence is being obtained or is being sought for the purposes of investigating a criminal offence. And for these purposes, the person who is being subject to the request is entitled to take a fairly broad brush view of whether the material is or may be incriminating. That's always been the case at common law, and it's certainly the case under Strasbourg. In fact,
submission that all compulsory process which results in the production, or is intended to result in the production of evidence, amounts to physical or psychological pressure.
and that's why
Where do you draw the line between some forms of physical and psychological pressure and others?
So, my lord, in Murray, the Strasbourg court considered the degree of indirect compulsion that eventuates from being put in a situation where an adverse inference can be drawn. And the court held that that was not enough to engage the privilege against self-incrimination.
How would you apply this, for example, to the obligation of a party on discovery of documents? No, production is compulsory.
It doesn't, in a civil context, of course, at common law, a person is entitled to rely upon the privilege, even though they're not charged with a criminal offence.
Yes, but let us suppose that...
But we're not in that category here. So
I'm not sure that resolves the dilemma, does it? Because there are lots of cases in which a civil action is being brought based on some criminal conduct, usually fraud.
Yes, and what
does the person who is alleged to be liable for fraud, is he entitled to say, well, buried in these 6,000 documents in my business files, there may be all sorts of things that suggest I really did commit this fraud?
Well, there is a solution that Parliament has. So the series of cases that started with Rio Tinto Zinc and Westinghouse, and then Rank Films, and then AT&T, Istel and Tully, coincided with a number of parliamentary initiatives, starting in 1968 with the Theft Act, 1968. Now, the Theft Act, 1968, Section 31, created a use immunity in civil proceedings. So it removed the privilege, but it created a use immunity in relation to any statements or documents created, see Bank of England and Riley. And because the Theft Act didn't apply in relation to passing off and other intellectual property claims, it wasn't possible to use Section 31 in the Westinghouse case, in the Rank Films case. That was subsequently remedied very shortly after the Rank Films case by the introduction of Section 72 of the Senior Courts Act, or the Supreme Court Act, as it then was. And then, of course, in AT&T, Istel and Tully, the problem that was identified was when the offending amounted to fraud. And what the House of Lords did in AT&T, Istel and Tully is that they adopted the approach taken by the judge at first instance of creating a use immunity in relation to both the documents and the statements that were made. But subsequently, the Fraud Act 2006, Section 13, created a statutory use immunity in relation to both documents and statements. So, my lord, the answer to your lordship's question is that as long as there is an enforceable use immunity, then it is okay to overbear somebody's will and force them to answer questions. That has always been our case. We're not saying that we can't be forced to answer the questions. We've always said that we can only be forced to answer the questions if you can guarantee that insofar as we are entitled to rely upon the privilege, so that depends on me establishing that it covers documents, but if it does cover documents, then the answer is to provide a use immunity. And that
You're
use
assuming there that it does cover documents, which is the whole question.
well, that is the premise, my lord, yes, but of course I've taken you now to the authorities which demonstrate that in fact documents are covered as a matter of Strasbourg law. And the only question then is, well, in what circumstances can the privilege be abrogated under Article 6 when, and the answer to that is, well, there's only one set of facts that have ever been found to be sufficient to abrogate entirely the privilege, and that is the so-called driving cases. And the
Speaking of the use to which the documents may be put, if these documents are exigible, are they admissible in evidence or merely a means of driving the investigation?
a use immunity.
No, I'm not talking about a use immunity at the moment. I'm just talking about as a matter of practical reality. If the documents have to be yielded up, can they be produced by the prosecuting authorities in the trial against the...
Yes. Well, I mean, in Norway, the Norwegian tax authority wanted to obtain the evidence in order to decide whether to carry out an investigate, or in order to decide whether to prosecute.
That's the point that I'm trying to get at.
Yes.
In Jersey, because we have to concentrate on Jersey now,
Yes.
If these documents are produced, would the prosecuting authorities in Jersey be entitled to adduce them in evidence on any criminal prosecution?
That depends on the answer to your lordship's judgment on the first issue. So if documents are covered by Article 6, then the answer is no, they would not.
No, of course not. I mean, I'm assuming that we will, well, not that we will decide, but I'm asking you to deal with the question on the basis that the documents will be required to be produced. And I want to know whether they merely are source material for further investigation or whether they can actually form part of the case against the proposed offender.
They can form part of the case against us at the moment, putting to one side the application of Article 6 and dealing with the 1991 law, because as a matter of, but as a result of the Ex parte Smith case, Section 2 of the 1991 law notice will be interpreted in the same way as Section 2 of the 1987 Act, as only creating a use immunity in relation to statements, which means applying Ex parte Smith in answer to your lordship's question, the prosecuting authorities would be entitled to rely upon any documents produced by Volaw. It's only if you are with me that, in fact, the use immunity for Article 6 purposes needs to go further and needs to cover documents as well.
Quite.
The answer would be
It just occurs to me that if it is the position that these documents will be admissible in evidence, then the question arises, what is the distinction between someone being required to give evidence in the form of oral statement and the requirement or the obligation to give evidence in the form of documents which may incriminate?
Well, our respectful submission would be very little indeed. That is to say that if it's incriminating, then the fact that it's an incriminating statement rather than an incriminating document doesn't make it any less incriminating, and it doesn't mean that the individual's been any less subject to the cruel trilemma.
If it was a document amounting effectively to an admission, is to put the case at its highest, there would be no reason why such a document should not be subpoenaed from a third party if he had a copy of it, is there?
My lord, I think I might be able to answer the question that you're driving at, which is, does the material have to be incriminating for the privilege to apply to it?
I'm just assuming that it is, simply in order to identify the getting at, which is that there's nothing wrong with deploying such documents. I think your submission is the only thing that's wrong is getting them from one particular source, namely the suspect himself.
Well, if the information can be obtained in some other way, then that doesn't engage the privilege.
Including search warrants, as you said.
Oh, yes, and the and the answer why a search warrant doesn't engage the privilege is given by Lord Justice Judge in the Bright case, and it's set out in our supplementary case, but I'll give you the reference. It's volume 5, tab 58, at page 3581, and it's at pages 683 to 684. And in essence, the difference is that under a search warrant, the individual is not compelled to cooperate in incriminating himself or herself. Oh, my Lord,
That's a distinction between active and passive cooperation. I mean, is there much in that? If you can be prosecuted for obstructing a police constable in the execution of his or her duty, is the compulsion of a materially different nature?
Can I answer it in this way? The domestic courts have always taken the view that a search warrant does not engage the privilege against self-incrimination.
Yes.
I've got Lord Wilberforce's speech in the Rank film case here in front of me, which is at page 2158 of the bundle, volume 2, tab 20. And it reads as follows: the orders under 2, that's to say the search warrant orders, were upheld by the Court of Appeal, and this part of the court's decision was not seriously contested in this House. In any event, I am satisfied there was jurisdiction to make these orders and that the privilege against self-incrimination has no application to them. That was the search warrant. That was the Anton Pillar orders authorising search. It was only those that authorised the production of documents and the making of an affidavit that were held to engage the privilege. So
Sorry,
the first...
is that actually right? Because the search and seize order in the civil jurisdiction requires the person in control of the premises to let you in.
My Lord, I can take you to what Lord Justice Judge said about it in Bright, but I'm running out of time.
Yes.
There's some other matters I'd like to
If
deal
you give me the references, I can work it.
Yes,
Thank you very
it's
much.
page 683 to 684. The whole passage is set out in our supplementary case.
The real question is not whether these propositions are supported by authority, as they plainly are, but what is the underlying logic which ought to impress us? Because if one is presented with a situation when, without any intelligible distinction between a search warrant and a demand for production, the law becomes incoherent, that may well be a good reason for supposing that the law is different.
Well, my Lord, one answer, which might be an unsatisfactory one, is Strasbourg has made that distinction. That lies at the heart of paragraph 68 and 69 of Saunders. My Lords, the other answer may not be an answer at all, but might be a demonstration of why your Lordships are right to ask the question, what is the difference? Because in Canada, what the Canadian Supreme Court has done is to treat all conscriptive evidence as potentially falling within the privilege against self-incrimination as one of the fundamental principles of justice under Section 7 of the Charter. But what they do is they then carry out a balancing exercise. So, for example, in the Stillman case, which is referred to in our supplementary case with the relevant passages, in the Stillman case, the court held that a DNA sample fell within the privilege against self-incrimination. Well, of course, under the Strasbourg approach, unless that was obtained in some way that was unduly coercive, a DNA sample does not fall within the privilege for the purposes of Article 6. So, my Lord, the answer to your question is that there are different approaches that have been taken by different jurisdictions as to the problem of where do you draw the line with the privilege against self-incrimination. And what the Strasbourg Court has done, and this is why paragraph 110 of Jallow is so important, the Strasbourg Court explicitly addresses those jurisdictions that have drawn a distinction between testimonial evidence that does fall within the privilege and other evidence that doesn't, and said, well, the Strasbourg approach is different. Ours is not linked to the testimonial aspect. Our approach is linked to the degree or nature of coercion.
But is Ibrahim the most recent Grand Chamber assistance on this issue? Because there they do seem to have narrowed down, arguably, the sort of Funke approach to cases of physical or psychological pressure. And the three examples they give, Jallow is what we know about that, McGeehan is about, I think, detention, and Gefgen was about sort of threats of violence. So,
With the greatest respect, I don't think that one can read Ibrahim as somehow overturning.
well, trying to understand it as we're all trying to do. And those are the three categories they pick out.
And the category into which we fall is psychological pressure that is used to obtain documents, which is specifically.
No, but I'm right, aren't I? That those three cases they give are cases of physical pressure.
They are not privileged case. They're not compulsory questioning cases like Funke and JB. And I agree, my lord. It would have been my job would be much easier if they had given us an example, Funke and
Yes,
JB.
they didn't, but no doubt for good reasons, because they didn't
my
think
lord,
it came within it.
You have my submission.
Yeah, very well.
Now, there were two other cases that I wanted to draw to your lordship's attention on the second issue, because it is.
I'm sorry.
Sorry,
I'm very conscious that you are running out of time.
Yes.
But if I can just ask one question, the critical phrase that the court uses in paragraph 269 of Ibrahim is destroying the very essence of
Yes.
of the privilege. Of course, that's an expression that's often used, and it's rather difficult to pin down what's meant by destroying the very essence. Is there any authority that helps us to understand what the court means by that?
Malinen?
Because the thing is, it's destroying the very essence of the privilege, not destroying the very essence of Article 6, which is a different question, and one which your lordship's house has certainly the.
It's getting a handle on the essence is the difficulty.
Yes, the essence. Essence is everything, my lord. But what I draw from those cases is that one cannot escape the conclusion that documents and other real evidence fall within the privilege against self-incrimination, that it depends upon the nature or degree of coercion as to whether they do, that there is a string of cases involving compulsory questioning and compulsory provision of documents which have been held to fall within the privilege. And in those cases, the very fact that they were obtained under compulsion has been held to destroy the very essence of the privilege. Now, my lords, my lady, that should be enough to see me home, because Strasbourg has spoken. Now, I've made the submission that the domestic courts have got it wrong. I'm just going to summarise the 4 reasons why the domestic courts have got it wrong. I realise I haven't taken you to the 2 other cases I was going to take you to, but I will come back to that when I look at the balancing exercise in a moment. But there's 4 reasons. The first one is that the English authorities adopted a testimonial, non-testimonial distinction in order to understand and interpret paragraph 68 and 69 of Saunders. And in doing so, they have drawn a distinction that the Strasbourg court does not draw, because the Strasbourg court is concerned with the nature or degree of the coercion, not with the nature of the material. The second error that they have made is that they've recognised that that interpretation of Saunders is at odds with both Funke and JB, and have concluded that therefore the Strasbourg court must have decided not to follow Funke. And indeed in the River East case, the most recent divisional court case, Justice Simon addressed the problem of the JB case by simply saying that it was incomprehensible. Now, my lords, my lady, the error that they have made is, as a result of the first error, they have concluded that documents don't fall within the privilege. But of course, if they do, then what they've in fact failed to do is to follow a clear and constant line of Strasbourg authority, which, in my respectful submission, this board should do unless there's a very good reason not to do so. Third, they have relied upon Canadian and other common law jurisprudence to support the distinction. But firstly, that is not a distinction that the Strasbourg Court makes. See paragraph 110 of Volaw. And secondly, in fact, on analysis, when you look at those cases, particularly the Canadian cases, they in fact apply the privilege against self-incrimination to a wider category of material than even the Strasbourg Court does, but then cuts it down by reference to the balancing exercise under Section 1 of the Canadian Charter. And the fourth error of approach by the domestic courts has been to misunderstand the rationale for the privilege under Article 6 and to give it a narrower rationale than in fact it has. So the courts have adopted a rationale that the only function of the privilege against self-incrimination is to prevent coerced confessions, in essence. See paragraphs 27 to 29 of the Attorney General's reference case. But that is not the rationale that has been identified by the Strasbourg Court. The Strasbourg Court has a rationale not only of avoiding coerced confessions, but also of avoiding abuses of state power and upholding the principle set out in Article 6.2, that it's for the state to prove its case against the individual. And, my lords, what it does is, in fact, it gives effect to the wider rationale for the privilege that one finds in other common law cases like Brannigan and Davison and Murphy against Waterside Commissioner, the US Supreme Court case. And both Commissioner Beloff and in the Royal Court and the Court of Appeal made the same errors. So, my lords, for those reasons, on the first issue, does Article 6 apply at all to pre-existing documents? We respectfully submit that the answer must be yes. The answer must, as a consequence, mean that the board will need to address the fact that there is a discordant line of authority up to Court of Appeal level in the United Kingdom to contrary effect. They must overturn the judgment of Commissioner Beloff and of the Court of Appeal on these appeals. But what about the difficult question, if Article 6 does apply, what are the relevant factors that need to be taken into account in deciding whether its use in the context with which we're concerned is a breach of Article 6? Now, you have my submission. I don't think I could make it any more forcefully that, in fact, the only situation in which the Strasbourg Court has found that the very essence is not destroyed by the use of compulsory powers of this kind has been in the driving cases.
Yes, but it doesn't seem to be very impressive because courts can only deal with the cases that actually come up.
Yes.
It's not as if being the other way around.
And I've taken you to the Lookoff and Spanner case, which is a post-O'Halloran case, which has made the distinction between the driving cases where only a very limited amount of information is being sought, which is the critical distinguishing feature, and cases like Funke and JB, which in the Spanner case, the Strasbourg Court explicitly said that doesn't apply. It doesn't undermine in any way the Funke and JB authorities. Now, my lords, what we say is that there are two features in particular of their cases where it would be open to you, and we respectfully submit you should say, that in any event there's been a breach of Article 6. The first one is as a result of the failure by the Comptroller to notify Volaw of the fact that a criminal investigation was being carried out at the time the tier notices were issued. And we derive that proposition from paragraph 272 of the Ibrahim case. I won't take you back to it, but it's the paragraph which says that the Convention is intended to guarantee rights that are practical and effective and not theoretical and illusory, in order to ensure that the protections afforded by the right to a lawyer and the right to silence and privilege against self-incrimination are practical and effective. It is crucial that suspects be aware of them. This is implicit from the court's application of the knowing and intelligent waiver standard to any purported waiver of the right to counsel. The court therefore finds that it's inherent in the privilege against self-incrimination, the right to silence and the right to legal assistance that a person charged with a criminal offence for the purposes of Article 6 has the right to be notified of these rights. And my lady, my lords, we respectfully submit that, come what may, you should find that in this case, it was wrong for the Comptroller not to notify the appellants of the fact that they were suspects, or maybe suspects, in a criminal investigation being carried out by the Norwegian authorities. My lords, my lady, the second aspect of this process, which we respectfully submit, demonstrates an error of law, an actual breach of Article 6, rather than just a failure to take into account Article 6, is the fact that no use immunity was offered in relation to the documents. My lady, for our purposes, it would be sufficient for you to conclude that that was not considered by the Comptroller or by the courts below because of their erroneous conclusion in relation to the application of Article 6. It would not necessarily mean that you would be concluding that in every single case there had to be a use immunity. It would only mean that you were saying that in every single case consideration had to be given to the use of a use immunity. But what we say, if one stands back from this, and if you do decide to go ahead and carry out the balancing exercise, applying those factors that the Strasbourg Court has laid down, that's to say, the degree of compulsion, the nature and degree of compulsion that's been applied, the existence of any safeguards, the use to which the information is to be put, the existence of any regulatory framework by which there can be implied consent to the measure in place. We say there are 5 reasons why the use of a use immunity in the tier notices appeal, why the absence of a use immunity mean that there's a breach of Article 6 that destroyed the very essence, or would destroy the very essence, of the appellant's rights. First, and this is set out in our case at paragraphs 111 to 116, the degree of compulsion is a high one. Non-compliance with the notices is a criminal offence punishable by up to 12 months imprisonment. And it's worth pointing out that in the JB case, the degree of compulsion was actually relatively minor. The offence of failing to comply only led to a penalty of 1,000 Swiss francs the first time and 2,000 Swiss francs the second time. But we respectfully draw the board's attention to the approach of the Court of Appeal in the case of Queen against K, open brackets A, 2010 QB 343, paragraph 42. I'll give your lordships the reference. It's in our case, but it's volume 2, tab 17, page 2056, where the court found that the use of evidence obtained under compulsion had been a breach of Article 6 and had destroyed the very essence of the right. My lords, secondly, the extent of the disclosure sought. Now, this is the key distinction to draw between the speeding cases and the other traffic cases and the cases like JB and Finco. In the present case, the appellants were required to supply information going back to 1982 relating to a number of companies and involving approximately 6,000 documents and 150,000 pages of evidence. And I've drawn your Lordship's attention to the Spanner and Lookoff case, which distinguishes the driving cases from cases like this one on that very basis. Third, the absence of any other suitable safeguards for the privilege under the tier regulations. I mentioned two more cases that I was proposing to draw to your Lordship's attention, and they are relevant in this context. The first one is Martin and Finland. I will take your Lordships to one paragraph in that case, volume 3, tab 28, at page 2563. It's paragraph 72. It wasn't a documents case, it was a statements case, but the key point that I wish to draw from it is the absence of a use immunity meant that the court found there was a breach of Article 6. So paragraph 72, the government pointed out that the obligation to provide information in the enforcement inquiry should be considered against the background of the protection by the provisions on confidentiality of any incriminating information received. The court notes that it's true that the bailiff was bound by professional secrecy. However, it's not apparent that the creditors applying for enforcement were prohibited from using any information received to their personal benefit in the pending criminal proceedings. Thus, the application of the Openness of Government Activities Act could not change the choice presented by Chapter 3, Section 34D. Either the applicant provided the information requested, or he faced the imposition of an administrative fine. And then this. The court also notes that the government did not refer to any domestic case law which would have authoritatively excluded the later admission in evidence against the application of any statements made by him in the enforcement inquiry. And my lords, what this demonstrates is that leaving it to the discretion of the trial judge is not a sufficient remedy for the purposes of Article 6. There needs to be a guaranteed use immunity.
Well, if there had been evidence as to relevant law, that would have been enough, wouldn't it, on that particular point?
If there had been case law which authoritatively excluded, not left it to the discretion of the trial judge.
Yes, so it meant he had to exercise his discretion in a particular way.
Well, which means that there would have to be an effective use immunity. That's the point. You can't say that there's a...
I had understood use immunity to mean an assurance from the issuing authority. Yeah, but this is saying if there's a clear law, a legal rule, that's enough.
Well, if there is a clear law which authoritatively excludes it from being used in evidence, then that means there's no breach. And that is our case, my lady.
Indeed, I understand it. I understand
which is why we sought a use immunity in this case.
Yes, this paragraph is very helpful to your case because it's talking about risk. Yes. You don't have to show that you were convicted on the basis of this evidence, but there was a risk you would be. So that's helpful to you. But it is based on the question of what would happen by use of the information.
My lady, if you just turn over the page 2564, and the court's conclusion. The court accordingly finds that the concerns for the effective functioning of the debt recovery procedure relied on by the Finnish government cannot justify a provision which extinguishes the very essence of the applicant's rights to right to silence and against self-incrimination guaranteed by the Convention. So there's the very essence point. This was the situation in the applicant's case at the material time. And then this, the mechanism introduced by a subsequent amendment to the legislation prohibiting the use of incriminating information in order to circumvent provisions on testimony or in order to have the debtor charged with a criminal offence, came too late. So they did, in fact, introduce a use immunity, but later on. And the other case, my lady and my lords, is the case of Van Wierelt. Van Wierelt is the case that goes the other way, where, in fact, that was a documents case, but the court found there was no breach. And they found there was no breach because the Dutch Supreme Court, when considering the legality of the order, imposed a use immunity. So you'll find that at page 2633, it's volume 3, tab 30. Paragraph 60, and I apologise for whizzing through these at great speed, but although endorsing the order, that's to say the order for disclosure, the Supreme Court qualified it by adding the restriction that insofar as the information to be provided concerned material the existence of which was dependent on his will, it should be supplied subject to the restriction that it should only be used for the levying of taxes, not for the purpose of imposing tax fines or bringing a criminal prosecution. In so doing, the Supreme Court had regard to the court's case law, in particular JB. In view of the case law set out above, in particular the Allen and King decisions, the court accepts that the Tax and Customs Administration was entitled to compel the applicant to give information that could not be obtained from any other source than the applicant himself for the purposes of levying taxes and interest in accordance with the applicable tax legislation. It further accepts that the Supreme Court acted preemptively to prevent the misuse of this information for the purpose of determining a criminal charge against the applicant. And my lords, what we say is that, well, that's exactly what the government did in the 1999 Criminal Justice the Youth Justice and Criminal Evidence Act 1999. After the Saunders case, they took steps to preemptively protect against violations of Article 6 by including use immunities in relation to statements. But we respectfully submit didn't go far enough, because Saunders did not make the distinction between statements and documents. That was the assumption upon which those amendments were made.
Also, for the rather fundamental reason that statements have the potential to be just as incriminating, if not more so, than documents have the potential to be just as incriminating as statements.
That is our submission. So, my lords, the absence of a suitable safeguard is the third reason why the current mechanism does not go far enough. And we would point out that had a request for cooperation been made by the Norwegian criminal justice authorities, which had then led to an order under the Criminal Justice International Cooperation Law 1991, that would have in fact conferred a use immunity in relation to documents. See Article 5A1 of the Criminal Justice International Cooperation Law 2001, which is at volume 4, tab 33, page 2667. Fourth, we say there are no special features of the TIA legislation, the TIA process, that justify the use of compulsory notices for the purpose of a criminal investigation into the individual upon whom the notice is served. And we would point out, we've taken you to the model tax information exchange agreement and the commentary to it, which demonstrates that it's not intended that the use of the TIA process should violate rights, including rights of self-incrimination. So it can't be said that a company engaging in trust and corporate services has impliedly consented to a process that removes their privilege against self-incrimination for the purposes of complying with Tax Information Exchange Act requests. Fifth, this is not a case whereby engaging, well, in fact, that's the same point, that it's not a regulated activity where the appellants can be said to have impliedly consented to these violations. My lords, as far as the 1991 law notice is concerned, we've made the point that Section 2 already breaches Article 6 because it doesn't have an equivalent provision to Section 2(8AA) of the 1987 Act, and we do respectfully submit that that is relevant in the balancing exercise. Moreover, we submit that that amendment to the 1987 Act was introduced on the basis of a mistaken understanding of Saunders, and so you can't draw the conclusion from the existence of provisions either in Jersey or in the United Kingdom, that Parliament has formed a view that the privilege should be excluded in relation to documents if that was made upon the basis of a mistaken understanding of Article 6. But in terms of the relevant factors, firstly, the degree of compulsion is a high one. Non-compliance with the 1991 law notice is punishable by up to 6 months imprisonment. Secondly, the extent of the material that may be sought is considerable. It's not quite as significant as that under the tier notices, but it's still voluminous. Thirdly, the absence of any other suitable safeguards. And I repeat the submissions I've made in relation to the absence of a use immunity. And fourth, again, we would respectfully submit that in the context of the 1991 law, there are no special features of that law, nor can there be said to be a particular regulatory environment in which a company like Volaw can be said to have impliedly consented to their privilege being removed when they are being investigated under the 1991 law notice. That destroys the very essence of their right. My lords, my lady, it's been a whistle-stop tour, but those
Well, before it stops,
are my submissions.
can I ask, the law in Jersey giving effect to the convention has a similar provision to the UK Act
Yes.
concerning taking account of Strasbourg jurisprudence.
Yes, I should have
I'm wondering,
taken
is there Jersey authority on what the content of that obligation amounts to, taking into account?
I'm going to pass that one over to Mr. Sharp to answer. But it's exactly the same provision. Section 3 of the Jersey Human Rights Law is exactly the same as...
Yes,
sorry,
but
Article 3.
Obviously, Section 3 has been interpreted quite extensively
Here,
in
yes.
the UK. I'm just wondering if there was any authority in Jersey.
If Mr. Sharp doesn't give you an answer, I will endeavour to... Well, I will have an answer for you by tomorrow. Unless there are any other questions that your lordships...
No, thank you very much,
should have.
Mr. Bowen. Mr. Leaf, do you follow? Mr. Attorney.
My lady, my lords, before I address you on Article 6, can I just make clear how any documents obtained by a compulsory notice might be used in a case, and in particular, perhaps pursuant to the investigation of fraud law powers. The court's already been taken to the interaction between the ability to request documents and the ability to summon someone to interview and be compelled to answer questions. What typically happens is that the first step is to obtain the documents from a party. And then the second step very often is to interview the holder of those documents to ask them questions by reference to those documents. And very often a witness statement will be compiled based on those questions, which in turn, of course, have been based on those documents. So in answer to the court's question of earlier as to what use would these documents be put if obtained, the answer is that they are a central part of an investigation. They are a crucial part in getting to the truth of the matter. One of the purposes of having the compulsory interview is because individuals who may not be the chief suspect may be sufficiently connected to that suspect that they will be to some degree tainted by any criminality, to the extent that it is embarrassing or indeed very difficult for them to answer questions truthfully unless they have the protection that their testimony will not go into court proceedings against them. One of the purposes of providing you with Mr. Tobias's affidavit is to show you, or to try and provide simply a working example as to how it is that witnesses who may have embarrassing things to say can be, there's a method of making them say those things in a way that enables a prosecutor to put a case together to gather vital evidence.
But the documents themselves would not be introduced in evidence.
Oh no, they almost certainly would be adduced in evidence. either in support of whatever the witness was saying to prove that certain facts had occurred, or it may be admissible against the defendant in the dock because they prove something did or did not happen, which is of relevance to whatever is trying to be proved. But what is for sure is that when one looks at Jersey and the sort of cases that we see, typically money being moved internationally, often allegations of money laundering, perhaps with predicate offending occurring overseas, there's no doubt that the documents held in Jersey are of key importance in terms of furthering those investigations. So I wanted to be clear that there is no doubt that if documents are obtained, they are always of vital importance both to the investigation and indeed the presentation of any case during trial. My lady, my lords, the issue in this case, or perhaps the primary issue, is what is an acceptable method of obtaining documents in a manner that is lawful and does not fall foul of Article 6. The appellants appear to accept that the use of a search warrant is such an acceptable method. It also appears that the appellants accept that the use of reasonable force when executing that search warrant is also a lawful way of obtaining those documents. However, it is said that the use of a compulsory notice that provides that person with an opportunity to avoid the need for the invasive nature of a search, that avoids the need for any use of force whatsoever. It is said that this less intrusive tool is the problem, and that it, and not the search warrant, will render the poor person subjected to it in a cruel dilemma, and therefore there will be a breach of their human rights. In our respectful submission, the position is rather different and much more straightforward. There is no functional difference between a search warrant and a compulsory notice. They are functionally the same. They constitute the taking of a thing from a person by a public official without that person's consent. There is no material difference. Volaw don't face any difficulty or dilemma or trilemma. Their options are very straightforward. On the one hand, they can comply with the notice, and in doing so, they can provide the documents in a way that is unintrusive and protects their business reputation. There is nothing worse in a small island than seeing a group of police officers knocking on your front door in a busy high street and spending all day in your premises. That is, in my respectful submission, the potential violation of a person's dignity, not the provision of a notice by means of private correspondence. The whole point is that the compulsory notice is intended to keep the level of intrusion and difficulty to a minimum. It is only when that step fails that a public official is entitled to go to a judge and suggest that there are grounds for the more intrusive option, which of course is the search warrant. Very little, if any, substantive differentiation was drawn between the search warrant and compulsory notice during my learned friend's submissions. May I please, starting with bundle 1, go back to look at the regulations at page 1611. So, sorry, 1616, behind tab 4, please. At the bottom of page 1615, we see regulation 15 and offences. And at subsection 4, we can see that a person who knowingly and without reasonable excuse obstructs a person who is executing a warrant under regulation 12 is guilty of an offence. So for the purposes of the tier regulations, whether you fail to comply with a notice or whether you fail or whether you obstruct a person executing a warrant, the effect is the same. You run the risk of criminal sanction. The investigation of fraud law is slightly different, which is behind tab 2. There is not the explicit offence of obstructing someone during the course of a search, but if one looks at the very bottom of page 1596 and the top of 1597, one can see that if any person at A knows or suspects that an investigation by the Attorney General into serious or complex fraud is being or is likely to be carried out, and B falsifies, conceals, destroys, or otherwise disposes of documents which the person knows or suspects or would be relevant to such an investigation, you'll see that that person would be guilty of an offence. And in addition to this statutory offence, there is of course the Jersey customary law offence of obstructing an officer in the course of his duty. So whether under the statutory provisions of the regulations and the law, or whether at Jersey customary law, the position is that in the context of experiencing a search, one still run the risk of criminal sanction. And that, as best I understand it, was the only distinction being drawn between a search and a notice. My lady, my lords, I invite this court to consider that there is a fundamental difference between pre-existing documents on the one hand and being required to answer questions or give testimony on the other. Pre-existing documents have an independence from the person concerned. They speak for themselves in terms of their relevance and probative weight. They exist independently from the will of the suspect. By that I mean that the suspect does not have to do or say anything to create that evidence. On the contrary, by definition, those documents already exist, they pre-exist. It is in one sense no different from someone or a police officer seeking to seize a knife in a murder case. It's an important distinction which, in my respectful submission, wherever we end up in terms of analysing the Strasbourg jurisprudence, it's an important distinction that is still there in the different decisions that we've been looking at this morning. I wonder if we might start perhaps with Saunders, please, which is in bundle 3, page 2567.
Are you at some point going to be addressing us to any extent about the facts of the relevant to the appeals? Particularly, I'm thinking of the changing situation in relation to the 1991 the notice issued under the 1991 law.
Yes, I will be addressing.
You will be.
Of course. I was just conscious that having looked at the decisions today, and I'm conscious I'm split over 2 days, I thought I'd, whilst it was still fresh in your
Yes, of course.
mind.
Yes, that's perfectly all right.
2567 of the Saunders is the start of Saunders. And if we look, please, at 2588, one has the submissions of the applicant in summary form. And at paragraph 60, you'll see that he expressly cites the case of Funke. And then you'll see that he also cited the Constitutional Court of South Africa just a few lines further down, and the footnote of 32 takes us to Ferrara, and we'll see in due course that Ferreira even had cited in turn the Canadian decision in Thompson, which in turn was cited by the English Court of Appeal in AG's reference number 7, when justifying a distinction between documents and testimonial evidence. So that was the basis upon which Mr. Saunders presented, or part of the basis upon which he presented his case to the European Court. And if one looks at the bottom of page 2588, one sees the government submissions. And if one goes over to the page, one will see between the two hole punches that the end of that second paragraph on the page, there's a passage which reads, "Nor does it follow from an acceptance of a privilege that the prosecution is never to be permitted to be used in evidence self-incriminating statements, documents or other evidence obtained as a result of the exercise of compulsory powers. Examples of such permitted use include the prosecutor's right to obtain documents pursuant to search warrants or samples of breath, blood or urine." So, pausing there, what the court had before it was Mr. Saunders presenting both fungal but also Commonwealth jurisprudence which distinguished between documents and testimony on the one hand, and on the other hand, the UK government also saying that there were limitations to the privilege against self-incrimination, and in particular, that there were examples where it did not prevent the obtaining of documents and other evidence which might be described as real evidence. And by way of just one final piece of background, and I appreciate it's out of turn, but if we go forward, please, to page 2594. One can see at 2594, top hole punch. It is noteworthy in this respect that under the relevant legislation...
Say the hole punches don't appear in the electronic...
I'm so sorry.
We don't have problems.
I'm so sorry. If we look, there's a very short line at the top of the page, and then there's a longer paragraph. So in fact, just above paragraph 75, if one goes up 7 lines...
It is noteworthy.
Thank you so much, my lord.
Okay.
It is noteworthy in this respect that under the relevant legislation, statements obtained under compulsory powers by the Serious Fraud Office cannot, as a general rule, be adduced in evidence at the subsequent trial of the person concerned. So there appears to be a clear indication that the Criminal Justice Act of 1987 was before the European Court during these arguments. And in my respectful submission, that is the key background to which one comes back to the key paragraphs we've already looked at, I know, which are at page 2591, which are paragraphs 68 and 69. What the court is saying, in my respectful submission, at paragraphs 68 and 69, is that Article 6 and the implied right to silence and privilege against self-incrimination is primarily designed to stop improper compulsion, to stop miscarriages of justice, and to prevent oppression on the part of the state. But it clearly notes at the start of paragraph 69 that that right against self-incrimination is primarily concerned with respecting the will of an accused person to remain silent. And if one goes over the page, the European Court clearly states that it does not extend to the use in criminal proceedings of material which may be obtained from the accused through the use of compulsory powers, but which has an existence independent of the will of the suspect. And then it gives the examples we are all very familiar with, but of course includes the obtaining of documents. But if one breaks that passage down, one notes two things. First of all, the court is saying there that the use of compulsory powers does not engage with Article 6. And secondly, it speaks about evidence having an existence independent of the will of the suspect. And in my submission, there is a difference between something having an existence independent of the suspect and the method by which you obtain it from that person. They're not the same thing, they are different concepts. And Volaw and the appellants in our submission are conflating those two different principles. All the European Court is talking about here is that the existence of the evidence is independent of the suspect. And although one might phrase it differently, one reads that to mean that the suspect does not have to do or say anything for that evidence to come into existence. It already exists. The document already sits on the office shelf. The blood is already in his body with whatever alcohol may be there too. So it's not about the suspect doing anything, it's about the use of compulsory powers to get that which is already out there somewhere in the ether. It is about no more than bringing relevant evidence to the attention of the authorities and in due course the court.
In some of the later cases, Jallow being an obvious example of real evidence being obtained in breach of Article 6, and the more recent Grand Chamber judgments suggest, it could be argued, they suggest a move away from basing the decision on a categorization of the material towards a decision based on considering a variety of factors to do with the degree, the nature and degree of compulsion that's involved in obtaining the evidence, what sort of safeguards the system contains, what the public justification, what the public interest is that's involved in obtaining the information. It might be said there's been a change in the court's approach in the more recent case law.
My Lord, I accept that there have certainly been, my overarching submission is I entirely accept that there have been, in cases of what I would describe as extremists, examples of the European Court finding principles to address those particular examples of extreme behaviour. My submission is that even that being so, there is still a core, there hasn't been a fundamental change away from Saunders. There may be exceptions to it if special features arise, but Saunders remains intact, and we'll see in a recent case involving Belgium, there was a search warrant executed, and it was all about the independence of the evidence that was obtained. But perhaps we can look at Jallow, as my Lord has mentioned it.
Well, let me take you out of order. I was just
no, not at all.
raise that possibility with you.
Well, it might be helpful to look at it now, in fact. So it starts at page 2473, so bundle tab
Are you coming
20.
back to paragraph 69?
I'm so sorry.
Are you coming back to paragraph 69?
No, I'm finished, my lady.
I was going to say it could be that what Strasbourg was trying to do was to reject the notion of the fruits of the poison tree. And all it was saying was that, all right, you can't use what the defendant has produced, but if that leads you on to something else, you can use that. Because the Serious Crime Act, as I recall, Serious Fraud Act, does make that distinction. As you pointed out, they had that before them.
Yes, and often in I believe in as a matter of English common law and Jersey customary law, even if an interview is ruled inadmissible,
It leads you on.
if it leads to the police discovering a hidden piece of evidence.
But that may not be true in other systems. It's not true, I think, in the United States.
Yes, I accept that.
So it could have been that's what they were trying to rule out.
Well, my submission would be that's not how that paragraph should be read. My submission is, if one looks at the start of 69, it makes it clear that the right is primarily concerned with respecting the will of the accused person to remain silent.
Right.
And therefore,
Follows from that.
my submission would be that that's the clue as to how the rest of the paragraph should be read, my lady.
Thank you. Sorry.
Your point is that in the case of documents that already exist, the accused is not required to generate any evidence. They
Precisely, my lord.
have a prior existence.
Yes, that is exactly the point. So, my lady, my lords, Jallow, if we start perhaps at paragraph page 2498. The court's been taken to these paragraphs before. What's interesting is that although at 101 we see for the first time the mention of the essence of the privilege, although that is not defined, albeit elements of it are mentioned. 102, we come back to the Saunders paragraph 69, in effect. So, I suppose my submission would be this. Insofar as there were tensions between Saunders and Funke and JB, Jallow was the perfect opportunity to iron out those difficulties and to say the court has moved on from the Saunders distinction. There is now one test and one test only. But what happens in this judgment is at 102, the court doesn't just effectively cite the Saunders paragraph 69. It actually makes a point of saying that that has been consistently held previously. And what one finds if one goes forward to page paragraph 109 is that the court explains that it needs to do two things. At the end of the paragraph, the court says it has to first of all define whether the right was relevant to the circumstances of the applicant's case, and if yes, whether there has been a breach. So in other words, before the court considered whether there was a breach of Article 6, it first felt the need to consider whether it was applicable at all. And if it had moved away from the distinction in Saunders, it would not have needed to do that. And I'm not seeking to suggest that this is the most cogent set of reasons. All I'm seeking to suggest is that actually the core distinction that's made in Saunders survives this judgment. What the court does, what the Grand Chamber does in paragraphs 111 to 116 is to effectively find reasons why this case on this facts is an exception to Saunders and why therefore Saunders does not apply. So to answer the question I was asked a short while ago, it's not a question of putting Saunders aside for some new broad sweeping test about the essence which is undefined. This case is simply about whether or not the court felt able to identify some other principle because of the extreme nature of the facts that arose. And that principle, one perhaps finds at paragraph 111, when it speaks of a broader meaning to Article 6, which the court had used on occasion. So sitting alongside Saunders, it would appear, is some form of broader principle in play. And the effect of 1112, 1113 and 1114, and perhaps even 1115, is to provide reasons why the court considers that the Saunders exception does not apply. In fact, if we look at 113, 4 or 5 lines down, there are several elements which distinguish the present case from the examples listed in Saunders. There is a clear indication in my submission that the court is preserving Saunders, but has gone on to identify reasons. And I don't necessarily suggest that they are the most cogent reasons.
How do you interpret the next sentence then?
Well, hence my prefacing what I said by saying it's not necessarily the most cogent of reasons. Can I say, because of course they then immediately go to Funke and JB, my submission about Funke and JB is they are cases which are not about a compulsion to provide the documents. That is the background to the case, yes, but it's not what's at the core of the case. What's at the core of those cases is that when a notice is served and is not complied with, rather than going to get a search warrant or write a letter to the German authorities seeking the evidence, they repeatedly bring the suspect to court, bring him through a criminal process, convict him, and either repeatedly fine him or fine him on an incremental basis.
I mean, would you say, in the sort of using the language of Ibrahim, it's more about psychological pressure? Is that the comparison?
My submission is going to be that Ibrahim's not irrelevant, but...
Well, it seems to be as useful because it does categorise the 3 cases which have been treated as exceptions.
But in the context of dealing with someone who's in police custody and being interviewed.
Yeah.
Because that's probably why Funke wasn't mentioned, because it's got nothing to do with Ibrahim at all, because Ibrahim is looking at what happens in a police station when someone's being interviewed. And the 3 different examples I believe are given are the sort of Jallow or Gafgan example, where there's either actual violence or threats of violence, the underhand behaviour with the informant in Allen, or there's some sort of threat that if you don't testify, something else will happen to you. So Ibrahim has got very little to do with documents. It's all about what happens in a police station.
I thought it might be seen as helping you, but maybe...
I
mean, here you find Funke, for whatever reason, being put in the same category as administering emetics, which seems a bit odd, but the only way you can, I see to me, possibly explain that is it's all about psychological pressure rather than anything else.
Well, it feels almost... I mean, what one might say about Jallow and Funke and JB Switzerland is if it happened in England or Jersey, one might be entertaining abuse of process arguments in the sense that in Jallow, if the police officer had behaved in that way, there would be an application for an abusive process because it was an affront to the justice system and all the evidence should be excluded. And similarly, there is absolutely no prospect of either an English prosecutor or a Jersey prosecutor repeatedly fining somebody in the hope of getting documents out of them. They would simply go to the court and seek the search order because there's not been compliance with the original notice. These all feel like I think Lord Hoffman in Ex Parte Green speaks about the wider principle of Lord Mustell about being able to tell people to mind their own business within reason. It feels like that is the sort of wider principle that's in play with Funke and JB, because it's not about, none of those cases, or any of the cases that are similar that follow, actually say it's wrong to request the documents pursuant to production order. They don't say that. What they're actually saying is it was the pressure, the repeated use of a criminal penalty to put pressure on the person to hand them over. That was the problem.
In which case?
In JB.
In JB. Because in Saunders, what one has to remember is that the prosecution chose to rely on the transcripts of evidence and not produce primary evidence of what Mr. Saunders had done.
Yes, of course. That is why I said at the beginning there is a massive difference between testimony and pre-existing documents. Saunders was required to create his own testimony. And of course, the minute he went in the witness box and started talking, the prosecutor was able to point out all the difficulties with his account by reference to what he himself had created pursuant to those compulsory interviews. I'm sorry to make my lady and my lordships jump around, but as we mentioned JB, if we go forward in the same bundle to page 2537, this is the JB judgment. And if one looks at paragraph 69, one can see at the end of that paragraph that between 87 and 1990, the public authorities found it necessary to request the applicant on 8 separate occasions to submit the information concerned, and when he refused to do so, they successively imposed 4 disciplinary fines on him. That is a repetitive, almost war of attrition between state and individual that simply isn't appropriate, and the potential for being fined under the fraud law or the regulations would simply not be used in that way, and if it was used in that way, one would expect the Jersey court to stop it. But the point is that you're given the opportunity to provide the documents pursuant to the notice, and if that, for whatever reason, that doesn't happen, then the next step is not to find the individual, but to apply for the search warrant, because that's the appropriate way to obtain the evidence the public official is seeking to obtain. So returning please to page 2501 and that rather problematic paragraph 113. What one can say about JB and Switzerland and Jallow is that they both constitute cases of behaviour which would not be acceptable to an English court or a Jersey court. That's what they have in common. What the problem with this paragraph is that that's not what's said. The problem with the paragraph is that it seeks to distinguish Saunders because it doesn't happen to mention this particular sort of real evidence, where it's perfectly obvious from paragraph 69 of Saunders it was just giving some examples. It wasn't meant to be an exhaustive list. So that is the issue, but whatever one makes of the strength of the reasoning, the Grand Chamber, in my respectful submission, felt it necessary to distinguish Saunders in order to arrive at the conclusion at paragraph 116 that the principle against self-incrimination is applicable. And they simply would not have needed to do that at page 2501 if, by this stage, the European law had evolved or developed to the extent that there was one overarching test. My lady, my lords, at paragraph 117, the European Court sets out what would appear to be 4 different factors to take into account. The nature and degree of compulsion, the weight of the public interest, the existence of any relevant safeguards, and the use to which any material so obtained is put. When we look at the next case, which is O'Halloran, it may be that not all of those factors survived. So if we turn to page 4402, please. Bundle 8, I'm so sorry, my lord.
(4482). Did you say?
4402, my lord. At 4402, hopefully is paragraphs 53 and 54, which the court has already been referred to.
No, I don't think so.
Yes.
Oh, yes, it is. Yes, I'm sorry. Yes.
One looks, actually, if one starts at paragraph 55, and we'll work backwards, but at paragraph 55, which is on 4403, you'll see that at the end of that paragraph, the court lists 3 and not 4 factors that it will take into account, so that the weight of public interest test isn't obviously in that paragraph, although one accepts that when one looks at the content of 57, when it talks about the duties of drivers who take on certain responsibilities, it may be that it was implicitly taken into account, but it's not obviously there.
But it does speak about the principles contained in the Jallow judgment.
It does.
Which might suggest that it wasn't departing from any of them.
No, I accept that. I simply note it isn't there. But also, if one goes back a paragraph to 55, again, this is another opportunity for the court to say that Saunders, we've moved on from Saunders, there's now one test. What the court says, or as far as it's prepared to go, is at the bottom of 54 on page 4402, even if a clear distinction could be drawn in every case between the use of compulsion to obtain incriminatory statements and real evidence on the other. The court observes that the Jallow case was not treated as one falling within the real evidence exception. On the contrary, the court held that the case was to be treated as one of self-incrimination according to a broader meaning. So, pausing there appears to be a recognition of the real evidence exception in the Saunders judgment. This paragraph, again, does not seek to say that that is of no longer of any relevance. What it appears to be saying is that sitting alongside it is a broader principle or meaning that one also has to take into account, which is where one arrives at this essence test. And what's peculiar about the essence test, well, there's 2 things. First of all, what is the essence? To which the answer appears to be nobody really knows. But secondly, the other startling or rather obvious thing in the context of a case about pre-existing documents is that there's no taking into consideration in this test as to the sort of evidence that we're talking about. Because if one accepts that there is at least in principle a distinction between testimonial evidence and real evidence in terms of what the defendant is required to do, if anything, in order to create it, one might have thought, if this was an overarching case, that it would at least be one factor, if not an important or indeed dominant factor, in applying some form of overarching test. And the absence of any reference to the nature of the evidence itself that's been obtained again tends to reconfirm that at least the core of the Saunders judgment has been retained in the Strasbourg jurisprudence. And just to show you the court an example of that, can we look at a case that does involve a search warrant, which is in tab 12, please. Page 6164.
Bundle 12.
I'm so sorry, yes,
Tab
bundle
12.
12, please.
Bundle 12.
Tab 133. This is the case of Kaunian-Nieni versus Belgium. And the facts are perhaps helpfully set out at page 6167. The police in Brussels, I'm looking at paragraphs 6, 7 and 8, the police in Brussels obtained a search warrant with a view to searching the flat of a suspect who was believed to be involved in a criminal organisation and trafficking. And they searched his property, which constituted one of many flats in the building. But they also performed a check, and they discovered that the appellant in this case also lived in the same block. And they also noticed that she had some form of criminal case file, and so they also searched her flat. And they seized various pieces of evidence from that flat. And at paragraph 10, one can see that during her police questioning on arrest, what they found in her flat was put to her, and she made various admissions. Paragraph 16 of the same judgment, one sees that she was sentenced to 5 years imprisonment, and the conviction was secured on the basis of evidence obtained on what was actually deemed to be an unlawful search, in that the courts in Belgium consistently ruled that they did not have a search warrant for the entire building, but merely the flat in respect of the person who had originally fallen under suspicion. That is perhaps set out in greater detail at 12, 13 and 14 on the previous page. So, one had an unlawful search, not a finding of bad faith, the securing of highly significant evidence, and the deployment into trial of that evidence with the result of a significant custodial sentence. The applicant complained, of course, and she complained on two bases. One, that the unlawfulness of the search was a breach of Article 8, and therefore there was a resulting breach of Article 6 on that basis, but also she brought a second basis of claim on the basis which was that her right of privilege of self-incrimination had also been infringed. And if we look, please, at paragraph 47, the European Court quoted from a case called Bykov versus Russia. It's quite a long quotation, but the relevant part is paragraph 92 of the quotation, which is on the next page, which begins, regarding the right not to contribute to his own incrimination and the right to remain silent. The court recalls that these rights are generally recognised international norms, which are at the heart of the notion of a fair trial. They are particularly intended to protect the accused against an abuse of coercion by the authorities. And then it goes on citing Murray and Saunders and all the other cases we've looked at. And it concludes, to determine if a proceeding has destroyed the very essence of the right to not contribute to one's own incrimination, the court must examine the nature and degree of the coercion, the existence of appropriate guarantees in the proceeding, and the use of the evidence obtained accordingly. So here we see the essence test again, and various criteria which are said to help guide the court as to whether or not the essence has been destroyed. At paragraphs 48 to 51, which we don't need to consider in any great detail, but the court found that there was no unfairness arising from the mere fact of an unlawful search. But if the key paragraph is at 52, lastly, with respect to the right to remain silent and not to contribute to one's own incrimination, it did not appear that the petitioner was constrained or pressured, contrary to the case of Allen, nor was the petitioner tricked into giving confessions or other incriminating statements. On the contrary, the evidence collected over the course of the search in question was material evidence that existed regardless of the petitioner's will. C. Saunders. So one immediately acknowledges, of course, that there is reference to Allen, which is a case about being interviewed in a police station by the police using an informant and subterfuge. But when one gets down to the meat of the judgment, what they're saying is the key factor here is that the evidence was independent, it already existed, it had an existence regardless of this woman's will. And we come back to Saunders. And indeed, we don't see any form of balancing exercise that one might have expected to see if the essence test is now the new test that has replaced Saunders. And that is why my submission has been quite careful to say that although there may be a broader principle out there for situations of extremis, Jallow, the Grand Chamber in Jallow, were careful not to put Saunders to one side. And in this particular case, which is one of the few cases that court's being invited to look at today which actually deal with real evidence, we're straight back to Saunders. And that is the principal reason for this decision. And it's not clear to what extent the essence test is really being applied here, if at all.
Aren't they implicitly saying that it's not a case where the essence was being destroyed because she had no right to prevent the use of documents or items obtained during a search, even though it was unlawful, because they were there already?
I read them to be saying that the key factor here is that the evidence that was obtained had a separate existence.
Exactly. Unlike Mr. Saunders' transcripts or transcripts of his evidence.
Exactly. That is why I said at the beginning there's such a difference between testimony and real evidence. It's so, and that's why it's unusual, or perhaps surprising at least, that if the essence test is the right test, it's not at least a factor, because clearly it's a factor in this judgment at the very least. That's why one wonders whether really does Saunders not survive. Sorry,
Well, I just need to observe, I mean, nobody's questioning the decision in Saunders, and it's referred to time and again. But if you look at what seems to be the most recent Grand Chamber consideration of this issue, which is in Ibrahim, where they look, I mean, it's by Strasbourg standard, it's a massive judgment and goes through every aspect of the rights of the defence in criminal proceedings, including the privilege against self-incrimination. And what's said there, I don't think is based on a categorization of a type of evidence, but rather or particularly the degree of compulsion applied, and whether, as they put it, the very essence of the privilege has been destroyed. And say that what's crucial is the use to which the evidence is put in the course of a trial, referring to Saunders as authority for that.
Yes, I wonder if it might be helpful to look at Ibrahim, my lord.
One is just so it's in the classic territory of privilege against self-incrimination. The other two have the common feature that they are concerned with methods of obtaining evidence which are either underhand or oppressive.
Yes.
So that unless one regards legal compulsion as inherently oppressive, which would be an ambitious proposition to accept, that seems to be the essence of it. You've done more than exercise your legal powers. You've done it in a way that is objectively oppressive or underhand. Now, it may be an additional requirement that you should have done it to such a degree as to destroy the essence of the right, which is really a reference to the result of the process rather than the method by which it's achieved. Is that a reasonable summary of what that paragraph is saying?
No, I entirely accept that that is an entirely reasonable summary of that paragraph. It's at page 2416, behind tab 25. Can I say at once that it may not matter for my purposes where one ends up with a final test, in the sense that even if there is now a broader overarching consideration, my submission would still be that we don't come anywhere close to infringing Article 6 simply by the use of a compulsory notice as a first step before the possible use of a search warrant. But if one looks at page 2416 and paragraph 267 in particular, one accepts the three examples given there are of some form of extreme act on the part of the authorities. I mean, if we look halfway down the paragraph where it says the first is where a suspect is obliged to testify under threat of sanctions and testifies in consequence, that's the context in which Saunders is being cited. So coming back to my lady's point about the fact that Saunders was required to testify and then under pain of sanction, but then that was then deployed against him in the trial.
In that context, they are talking about mere legal compulsion.
Yes.
It's the second and third cases which are relevant outside the field of oral evidence.
Yes, so the second...
Something more seems to be required.
Yes, and I understood my learned friend to be pitching the appellant's position to be very much in category 2, which is they're under psychological pressure. But obviously one has to read on and note that that psychological pressure has to be in the context of or appears to be in the context of a breach of Article 3.
Well, I mean, it wouldn't necessarily be limited to that.
No, but it's an...
Psychological pressure must consist in more than simply the application of legal compulsion. It's referring to something which is analogous to physical pressure because it is oppressive.
Yes, I accept all of that, my lord.
Some of those cases would no doubt fall within Article 3, but they're not.
Well, no, of course, but to give the court a flavour, Gafgan featured a suspect in custody in handcuffs who was told that unless he disclosed the location of the boy he had kidnapped, that physical harm would come to him by the police officer, and other such similar threats were made.
In the cases of Funke and JB might be thought to be cases of oppressive behaviour falling within that second category.
I accept that dragging someone repeatedly before the court and repeatedly fining them is not acceptable behaviour by an authority. I quite accept that.
Well, I think you were saying earlier that it would be regarded in England and Jersey as an abuse.
I would expect an abusive process argument, and I would expect the judge to be sympathetic to it, yes.
Which would fit it very neatly into that category.
Yes.
Yeah.
But it wouldn't have been an abuse if after the first refusal they had taken steps, e.g. a search warrant, to bring resistance to an end, whether the end result would have been the same.
No, I accept entirely, my lord. The problem with Funke and JB is that they're using the fine to get the documents. That's not what the fine is for in the Jersey legislation. It's simply there to mark a non-compliance of the law. In order to get the documents, one goes to stage 2, which is you go before a judge, and you explain the non-compliance with the notice, and then presumably if the judge is so satisfied with everything else, a search warrant is obtained, and that is how the documents are obtained.
Yeah.
Otherwise, one could imagine ancillary criminal proceedings going on for months and years, simply over the question of where the documents are, which would be an extraordinary state of affairs and would be a complete recipe for injustice.
In Funke, they draw a distinction between, in French, between une astreinte and une amende. And while there were repeated amende, i.e. fines, there were also astreintes, which are the daily penalty for failing to produce the documents, which are obviously designed to pressurize the person who's subject to them.
Yes, and I believe in all those cases there's some sort of fine of the European Court that the whole point of the fine was to put pressure on the person to hand over the documents. It wasn't to mark a failure to comply with some legal requirement. I don't ask the court to turn to it now, but in the Van Verel case, which is behind tab 30, at page 2623 at paragraph 29, in that case, the applicant was put on a penalty of €2,500 a day, and there was a maximum overall penalty of €500,000, which on any view is a significant sum of money. But returning to Ibrahim, if one accepts that a search warrant or the possibility of a search warrant and the use of reasonable force and some sort of potential criminal sanction, if there's no at least cooperation or no passive behaviour on the part of the suspect, if one accepts that that does not offend Article 6, then it is rather difficult to see why a compulsory notice would do so, given that the whole point of the compulsory notice as a first step is designed to avoid the need for such an intrusive measure. Well, I'm conscious of the time, but I was going to change the topic and move on to just briefly looking at some of the law on the difference between documents and testimony, because it's cropped up a few times. We start in bundle 1, please. And page 1872. This is Attorney General's reference number 7 of 2000. And the background, of course, to this very briefly was that there were insolvency proceedings, and as a result of those insolvency proceedings, the defendant was required to hand over various documents and real evidence, and he claimed the privilege against self-incrimination. The reason I've turned to this judgment is it's quite instructive in terms of considering the ambit of privilege and also the difference between documents and testimony. So, just by way of background, because I believe one of the appellant's criticisms is that the English courts have taken a rather narrow view of privilege. If we start at paragraph 25, please. Paragraph 25. In this, I'm not proposing to read it all out, but it's clear that the English Court of Appeal had regard to Lord Mustill's speech in Ex parte Smith. And my submission, they clearly had in mind when reaching their decision in this case a very wide understanding of what privilege was, and it wasn't just about the sort of narrow grounds that have been put forward as criticism of the English Court of Appeal decisions. In particular, if one looks at paragraph 26, there is particular citation. as to Lord Mustill's, what I might call more broader principles that underpin or have underpinned the privilege historically. What is helpful about this case is that it goes back to Saunders at paragraph 37, please. My lady, my lords, you'll recall that I took the trouble of a detour to show the court that Ferrara and Levin had been cited in Saunders as part of the build-up or part of one of the planks of Mr. Saunders' own case. And you'll see that the English Court of Appeal looked at Levin and noted that it had looked at Thompson, which is a Canadian case, and the judgment of Le Forest, who gave the majority decision. And the issue in Thompson was whether or not there was a difference between compelled testimony and evidence that had been obtained or found as a result of clues or information provided during that compelled testimony. So to give a very simple example, if during a compulsory interview the suspect had said, the folders are in my shed, for example, at the bottom of my garden, and the police had then gone to the shed and indeed recovered those folders, the issue that Thompson was considering is whether any privilege should extend to any evidence found as a result of those compulsory answers, sometimes called derivative evidence. And he was considering whether or not that evidence should be admissible. And these passages are really rather helpful. There are serious grounds on which objection can be raised to an absolute rule that testimonial immunity must always extend to evidence derived from compelled testimony. While allowing the Crown to use such evidence in criminal proceedings may in a formal sense be equivalent to permitting direct reliance on the compelled testimony itself, there is an important difference between the type of prejudice that will be suffered in the two cases. It is only when the testimony itself has to be relied on that the accused can be said to have been forced to actually create self-incriminatory evidence in his or her own trial. The compelled testimony is evidence that simply would not have existed independently of the power to compel it. It is in this sense evidence which could only have been obtained only from the accused. By contrast, evidence derived from the compelled testimony is by definition evidence that existed independently of the compelled testimony. This follows logically from the fact that it was evidence which was found, identified or understood as a result of the clues provided by the compelled testimony. Although such evidence may have gone undetected or unappreciated in the absence of the compelled clues, the mere fact that the derivative evidence existed independently of the compelled testimony means that it could have been found by other means, however low the probability of such discovery may have been. The difference between evidence which the accused has been forced to create, the compelled testimony, and the independent existing evidence he or she has been forced to assist in locating, identifying or explaining will be readily discernible. I believe its significance will be equally apparent. The fact that derivative evidence exists independently of the compelled testimony means, as I have explained, it could also have been discovered independently of any reliance on the compelled testimony. It also means that its quality as evidence does not depend on its past connection with the compelled testimony. Its relevance to the issues with which the subsequent trial is concerned, as well as the weight it is accorded by the trier of fact, are matters that can be determined independently of any consideration of its connection with the testimony of the accused. What prejudice can accused be said to suffer?
Are you wanting us to read?
I'm so sorry, my lord.
Are you wanting us to read the next two paragraphs as well?
Yes, please, my lord.
And are we then going to be going into this case further?
I'm happy to Not today, my lord.
Well, in that case, I think if we adjourn just now, you can trust us to have read paragraphs 39 and 40 by tomorrow morning.
Thank you very much, my lord.
My lord, sorry.
Yes.
I have to return to Jersey tonight, and I may be unable to attend upon your lordships tomorrow. For that I apologise, and I mean no discourtesy. And of course, Advocate Sharp speaks for me in relation to these matters.
Thank you very much, Attorney.